You may be seated.
This report is now in session.
Final argument today is in the case of Farthest North Girl Scout Council versus Girl Scouts of the United States of America. Counsel are present in court. Mr. Leidig, you may have opening argument.
Good morning, Your Honors, and may it please the Court, I am Gary Leidig. I am here today representing the appellants, the plaintiffs in this action, Farthest North Girl Scout Council, which is in Fairbanks, and its two principal officers, the chairman of the board, Russ Sharpton, and its CEO, Sue Ellen Nels. This appeal requires this Court to resolve a single issue. And the question raised by this single issue is, under the governance documents of the Girl Scouts of the United States of America, or GSUSA as it is typically referred to, which body within GSUSA has the authority to establish membership dues requirements? These are the dues that are paid by every member of Girl Scouts annually or occasionally on a lifetime membership. It's the annual dues we're talking about. The answer to that question is to be found squarely in the four corners of the Charter and the Constitution. And it is plainly written language, it is simple English language, and we are just asking this Court to read that language and rule on what it says. And it is my goal today to focus on four sentences in the Constitution, four sentences that is my opinion absolutely resolve the issue and unarguably require the conclusion that the National Council and the National Council alone has the authority to establish membership dues requirements. If Your Honors are so inclined to read along, I'm going to actually read those four sentences as I go through this. They are all contained in the authority section up front of both our initial brief and our reply brief. But if you're interested in seeing how these sentences play out in the entire document, where they fall in, the entire Constitution begins at page 24 of the excerpt. The first sentence is at Article 5, Section 2. It reads as follows, quote, "The National Council at its sessions shall hold elections, amend the Constitution, establish membership requirements, and shall determine the general lines of policy of the Girl Scout movement and program by considering and acting upon proposals directed toward the fostering and improvement of Girl Scouting, by receiving and acting upon reports of its board of directors, and by giving guidance to the National Board upon general lines of direction of the movement and program." This sentence clearly establishes in the National Council four categories over which it has authority, exclusive authority. It does not say the National Council and the board. It does not say the National Council or the board. It says the National Council shall, at its sessions, have authority to hold elections, have authority to amend the Constitution, have authority to establish requirements for credentials, which is precisely what we are here on today, and the authority to determine the general lines of policy of the Girl Scout movement and program. Somehow GSUSA has taken the position in this case that it shares that authority. Clearly, that conclusion cannot be reached from this sentence. The sentence allows for no such sharing. It is the National Council alone that has this authority. The second sentence I want to turn to is at Article 8, Section 1. It says, quote, "The National Council shall establish requirements for certificates of membership, local council charters, and all other credentials," close quote. Again, it does not say the board. It does not say the National Council and the board or the board. It says the National Council shall establish requirements for certificates of membership. And again, there is no way one can read that sentence and come to the conclusion that somehow the board shares in that power. It just is not to be found in that language. The third sentence I want to read is the companion to the one I just read. It is Section 2 of Article 8, and it not only reaffirms that the National Council alone has the authority to establish requirements, but it clearly states what the board's role is in this endeavor. And it says, quote, "The National Board of Directors shall administer the requirements for credentials established by the National Council and may establish standards and issue standards, procedures, and interpretations regarding such requirements, provided such standards, procedures, and interpretations are consistent with the requirements established by the National Council," close quote. I don't see how you could be any more clear as a draftsman than establishing that the National Council alone establishes the requirements. The board can issue standards and interpretations of those requirements. They can administer those requirements, but whatever they do, it has to be consistent with whatever the National Council has articulated as the requirement. The fourth sentence, Article 5, Section 5. I'm going to read two sentences here. The first sentence is the lead-in to give it context, and the second sentence is the one that matters. Quote, "Each member present in person at the National Council shall be entitled to one vote. Decision on membership dues shall require a majority of votes cast." Close quote. You could not get a line that is more case-specific to the issue in this case than a sentence that says, "Decisions on membership dues requires a majority of the votes cast by the National Council." So it is our position that, and those are the only four provisions in the entire Constitution that address membership requirements and membership dues. Time permitting here, I'm going to get to the one sentence that GSUSA relies on. Membership dues are not mentioned in it whatsoever. Based on those four sentences I just read, for 70 years, the National Council alone established membership dues. And they increase those dues approximately every 6 years. Their meetings are triennial. The National Council is a large democratically appointed body coming up from the councils all over the country. It contains about 1,500 delegates. It's a big convention. I think it takes 2 or 3 days, and they vote on key major issues that fall within their province. They increased the dues 7, 8, 9 times over that 70-year period. And in 2009, they established dues. They affirmatively voted and established dues in the amount of $12 per year. Then, in 2012, for the first time in the history of Girl Scouting, the board decided to establish its own dues. It did not present anything to the National Council. It obtained no consent of the National Council. It never presented anything to the National Council to vote upon. But the board increased dues by $3 from $12 to $15. And a few years later, the board did it again without presenting anything to the National Council. And this time increased dues $10, now more than doubling the amount, causing it to be $25, more than double what the National Council had last established.
And the board did this in a time period between the 3-year National Council meetings.
That is correct.
And as you know, and as we know, because we've read the briefs, you know, the other side, the Girl Scouts of USA, is going to point to the Congressional Charter, Section 80303B, and they're going to say, to the extent provided in the Constitution and bylaws, the Board of Directors shall have the power of the National Council and manage the activities of the corporation between the meetings. And they're going to argue that they exercised whatever authority there is in this section to raise the dues.
Correct. And the critical language in that section 80303B is to the extent provided. And I think it's critical that your honors understand that this is a membership-governed nonprofit. The underlying powers of this corporation are in the membership. And
Who is the membership?
I'm sorry?
Who is the membership?
The membership is actually, the way the District of Columbia statute is drafted, would be the National Council in terms of the fine-tuned definition per the Constitution. The members are the delegates to the National Council. So this section B that you just referred to, Your Honor, begins with the content to the extent provided. So we need to look in the Constitution to see to what extent is the board provided with the authority to establish dues. And the 4 sentences I just read are the only sentences that discuss membership requirements.
That's true.
Now,
these sentences don't say that the board can't, in the exercise of its authority, raise the dues. And if these sentences are ambiguous, can we take a look at the course of conduct following the raising of the dues to see did the National Council object in any way or attempt to rescind the raising of the dues? Is that a relevant question for us to ask?
Well, I think you had 2 questions there, Your Honor. The first one is what was does the board have the authority to do it in its ordinary course? And I think we have to
the extent that the Constitution doesn't affirmatively prohibit, which sounds weird.
But I think the Constitution does prohibit it because the express language says, it talks to it directly. It says, when we come to the issue of membership requirements, the National Council establishes them. The board only administers and establishes consistent standards. I don't know how, under any interpretation, a $15 dues and a $25 dues, I don't care what you call it, a standard, an interpretation, whatever, it's entirely inconsistent with $12. So the section in the Constitution that GSUSA hangs its hat on is Section 1 of Article 10, and it says that in between sessions of the National Council, the board shall manage the affairs of the organization. Well, they take that phrase, manage the affairs, as if it is saying, assume the powers of the organization. 2 totally different things. And I think it's critical that in both the Charter and the Constitution, powers and management of affairs are 2 very different things. In the section you just referred to, it talks about the board of directors shall have the powers of the council, and secondly, shall manage the activities of the corporation between meetings, and again, to the extent provided. So let's see how the Constitution provides it. At Article 4, Section 2, it clearly says the powers remain with the National Council. It says the National Council shall have all the powers conferred by the Congressional Charter and by other applicable laws. Well, applicable laws would be this D.C. statute, and it enumerates what all the powers of a corporation are. And that includes dues and the ability to borrow money and everything else. Then when we get to Article 10, Section 1, it very carefully does not refer to powers in that section. It says the affairs of the corporation between sessions of the National Council shall be managed by the National Board. It doesn't say the powers are imbued, and we know that Section 1 does not give the board the powers, because if you go down to Section 6 of that same article, it says only in the event of an emergency, when the National Council can't meet, then and only then can the board assume the powers of the National Council. And even then it pulls out and restricts the election of directors. So
before you run out of time at your opening, the second part of my question was, if we find this language ambiguous, is there any room for us to take a look at the course of history, noting the fact that the Council has not rescinded the raising of the dues or taken any action, apparently attempting to regain its authority to do.
Well, the problem I have with that approach, two things. You have the District of Columbia law, which has a very strict standard of how you interpret these types of documents, and they take an objective man view, and they even flat out say we aren't trying to find what the intent of the original parties was. They say if we read the words and the words say X, then that's the agreement, regardless of what the parties may have agreed. So you look very objectively at the words. Number two, this concept that if the National Council didn't take some action, then that's somehow a concession.
Or a ratification.
Ratification, I'll address that. That's a whole different issue, too. But let's say a concession. Well, then I think you are undermining, not just in this case, but any shareholder derivative action ever. Because an action like that is always because some governing body hasn't taken action. If officers misbehave and the board doesn't take action, well, you need an activist shareholder to come and say, you need to do this because the board didn't take action. Or if the board does something they shouldn't have done that's unauthorized and the shareholders never get together as a body and vote, you need an activist shareholder to come in and say, you need to make the board behave. If it was thrown back on that activist and said, well, they didn't behave, no one ever did anything, therefore because they didn't do anything, it was conceded, therefore you don't have a case. No one would ever be in my position to be able to present to a court misbehavior by a governing body.
Mr. Lighty, you are a couple minutes into your...
I'm going to keep going because I think this is very, very critical. In this situation, the board has not behaved. They've acted without authority. The council is admittedly an unwieldy, large democratic entity. Its agenda per the Constitution is largely dictated by the board. So it's not at all surprising that the National Council as a body doesn't take this up. It's not, number one, the board isn't going to put it on the agenda. Number two, like we all do when we get proxy statements in the mail with our investments, we assume when the board says, well, this is right, we have this power, we all go, oh, okay, we check the boxes, okay, we'll vote for that guy, we'll vote for that amendment, we'll do what? We rarely really investigate it. We really rarely doubt the authority of that authority figure who's telling us what is right. That's why these kinds of cases are always brought by an activist. Either someone who holds a significant minority share in a for-profit corporation, or here, a council who is highly vested in wanting to have the right thing done, and they come in and the statutes specifically allow for it. Because they know that the body as a body is never going to be able to pull itself together and bring a lawsuit. You need someone like Farthest North to do it. In ratification, very quickly, that's an affirmative defense. Never asserted. I'm not even sure, in fact, they've never still argued as far as I know. It's an affirmative defense. It needed to be pleaded. It wasn't pleaded. It's never been argued. It's waived. If ever there was a ratification argument, it's not in this case. Thank you, Your Honor.
Mr. Torgerson?
Gary, is this yours?
Thank you.
May it please the Court, for the record, my name is Jim Torgerson. I'm with Stoll Reeves and representing the appellee. Referred to as GS. To counsel's argument, and I'm going to refer to the appellants as Farthest North collectively. There's a lot that we agree about. We definitely agree that the council has the exclusive authority to set requirements. We also agree that the council in the past has set the amount of dues. And we also agree that the board has to act when the council set a requirement consistent with their requirement. What I was listening for was, and reading the briefing for, was an answer to the question, how does the amount of membership dues as compared to the obligation to pay membership dues, how does the amount of membership dues come to be a requirement? The word requirement is it's got a common meaning, but it's also, in the context of this case, in the governance documents here, got a very specific meaning. And in addition to the times when it's talked about in the Constitution, where it's never defined, it's also talked about in other governance documents. It's got a very specific meaning, and that question, how did the amount of dues become a requirement, is never answered. And if it's not a requirement, then all the rest of their argument just goes away. So let me talk a little. Can you be a member without paying it? Pardon me? Can you be a member without paying it? Sounds like a requirement to me. There's an obligation set forth in the Constitution that says that you've got to pay dues. Part of membership is paying the dues. So that's an obligation to pay dues that is a requirement, and there's no question about that. But the amount of the dues is not in the Constitution, and it's a different kind of question. And by that I mean that there are issues here both having to do with the structure, the governance structure of the GSUSA, and the governance documents themselves. On the side of the governance structure, and this is reflected in the documents, like most member nonprofits, GSUSA's members, the 1,500 council members who show up for the National Council meetings 3 times a year, have retained for themselves some authority, and then they made a general grant. What they retain for themselves is structural authority. That is, if you look at Article 5, Section 2, talks about how the councils retain control over elections. I'll come back to that. And then over these 3 subject matters that council referred to, one of them is amendments to the Constitution, another is general policies, and the third is requirements for membership. Those are all structural issues. Amendments to the Constitution, obviously structural, general policy, high level, and then the requirements for membership. Who gets to be a member? Again, it's a high-level structural issue. But for each of those areas, well, at least for the elections and for membership, the Constitution also talks about the delegation of authority for more operational matters. And the clearest expression of this, of course, is Article 10, Section 1, where the Constitution says that the board is going to have the authority to manage the affairs of the organization between meetings of the council. But as to requirements, Article 8, Section 2, also acknowledges what the requirement is, but then it says that the board has the authority to implement the requirements and to establish standards. There you go. Standards, procedures, and interpretations. So it's clearly making a differentiation between requirements on the one hand, which are these high-level, overarching structural pieces, and then the implementation pieces, the organizational pieces, the operational pieces. And so here the question is, which of those is a due? The obligation to pay membership dues, you can't be a member unless you pay membership dues. You can't be a member under the Constitution unless you pay membership dues to the national organization. That's a requirement. It's overarching, doesn't need to change every 3 years. But the question of what the dues should be, how much they should be, is operational. It's operational because it's something that does need to change at shorter intervals. It's operational because it goes to the organization's finances. And again, the Constitution in Article 8, Section 2, clearly makes this demarcation between the 2 categories of things that have to be done. Now, the problem with the word requirements, of course, is that people are required to do things that aren't requirements as that term is used in the Constitution. So it's got both its general meaning and then it's got its specific special meaning here. So back to the structural piece, the organization, the members reserve for themselves responsibility for these big overarching pieces plus control of the organization, so they reserve control over elections. And as you move through the Constitution, you can see that probably the longest sections in the Constitution, Articles 10, 11, and 12, are all about elections and about how the the National Council makes sure that it votes and has to have a majority vote for everybody who's elected to the National Board.
If the setting of dues was operational and intended to be in the board and not with the council, then how do you explain the language of Article 5, Section 5? Decision on membership dues shall require a majority of votes cast. And that's referring, isn't it, to the council?
No, it's not. I misspoke. That sentence is referring to votes by the council. But
why would they have that there if setting the dues is an organizational matter intended to be for the board of directors, as opposed to setting just a requirement that dues be paid?
Because the National Council has all authority, and it's delegated some of that authority to the National Board, but it's still, as to that delegated authority, has shared authority. So it still has the power to set dues. It's just that it doesn't have the exclusive power to set dues. So as to the dues, both the National Board and the National Council have that authority. And what Farthest North wants this court to read into that sentence is the words "shall be made by the National Council." That is, right now it says decision on membership dues shall require a vote, shall require a majority of votes cast. But what Farthest North wants the court to read into that sentence is that it would be decision on membership dues shall be made by the National Council and shall require a majority of votes cast.
But it's under the heading Sessions of the National Council. It's clearly talking about what goes on at the National Council sessions, isn't it?
It's absolutely talking about votes of the National Council.
So what other votes could it be referring to?
It's not referring to any other votes. But what it doesn't say is that only the National Council can make a decision about membership dues.
Well, Section 5 in Article 5 has another sentence that we haven't really focused on. It says all matters shall be determined by majority vote of the members present and voting, unless otherwise provided by the Constitution. Again, referring to the National Council, I assume.
Right.
All matters would presumably include dues,
right.
The amount of dues. So, given that sentence, why is there the preceding sentence? The decision on membership dues shall require a majority, and all decisions shall require a decision by the majority.
Yeah.
They're very redundant unless the dues-specific sentence has some additional meaning.
Yeah. So several explanations for that, and this is just from a textual standpoint because that's what the focus is on here. First of all, there are other provisions in the Constitution that provide for a majority vote. And so if the conclusion is that because Article 5, Section 5, talking about votes of the National Council, says that unless otherwise provided, everything is going to be a majority vote, all of those other provisions, which include include the section that provides for majority vote for the election of people to the board, it says they would all be superfluous. And nobody's arguing that every place in the Constitution where it says there's a majority vote requirement, it's superfluous. And I also point out there's some other parts of the Constitution where the same kind of idea, like Article 5, Section 2, that talks about requirements for credentials, and Article 8, Section 1, that talks about requirements for credential certificates, arguably are the same or duplicative as well. And nobody's saying that you've got to read in new words to those. But the other point here is that there is an important clarification that this sentence provides. And that is that the requirement, the membership requirement, is set forth in Article 9 of the Constitution. It's a requirement of paying membership dues. That's in the Constitution. To amend that under Article 17 would require a two-thirds vote. So if somebody wanted to change the requirement that you have to pay dues, that is, the obligation that you have to pay dues, there would be a requirement for a two-thirds vote. This sentence clarifies that if you're talking about the amount of dues as contrasted with the obligation to pay dues, it's a majority vote that's required. In the absence of this sentence, there could be confusion about whether a two-thirds vote would be required for a vote on membership dues as well. So it has that clarifying point. But I need to go back, I think, to the to the question about the authority to who has the authority to require that or change membership dues. The primary point here is that, and this is a point that Farthest North we just disagree about, is the effect of Article 10, Section 1. Because Article 10, Section 1 provides GSUSA with the authority to manage the affairs of GSUSA between the sessions of the National Council. Those are every 3 years, so it's a significant breadth of time. And under Washington, D.C. law, which defines what the affairs of the organization are, it's very broad, and it explicitly includes imposing dues. It also, and I'm not sure exactly how relevant this is, given that I don't really agree with the argument that Council's making about the difference between managing and corporate powers. I think effectively the delegated authority to manage means that to the extent that is a broad grant of authority, the board has the authority to manage whether it has some explicit corporate powers or not. But I would note that DC Code Section 29406.01, which is included in our materials, says that as to nonprofit corporations, their boards of directors shall have, quote, all corporate powers, and they shall be, quote, exercised by and under the authority of the board of directors of the nonprofit corporation. And that, of course, is subject to any limitations that are imposed upon the board by the National Council.
Council, I think this would be a good point for me to ask a question about your position on the reply brief. Farthest North contends that idea is different with respect to a membership nonprofit corporation or nonprofit corporation that provides for more power in the board. How do you respond to that?
There isn't any difference. Whether the board's power comes from the members or whether the board's power comes from the fact that it's a non-member organization and so the power is implicit in the board, it's always going to be whatever the extent that the board has. And so if it's a non-member organization, then the board just has whatever powers a corporate board would have. If it's a member organization, as GSUSA is, then you've got to look at what the grant of power from the members to the board has been. And the grant of power from the members to the board here is, again, very broad. It's all of the affairs of the organization except what's been explicitly held back. And that's the point that's really important here, because rather than looking through the Constitution trying to find a grant of authority to the board for it to be able to set the amount of fees, the question is there, or dues rather, the question is there a place in the Constitution where the Constitution states, where the National Council states that it's retaining for itself the authority to set the amount of dues.
That's really the ultimate disagreement between the parties here, isn't it? As to whether the powers have to be explicitly authorized in the Constitution or explicitly excluded in the Constitution.
Well, I think that's one of the disagreements. I think there's another one about what a requirement is, but I think that's one of the disagreements. And the Constitution, Section Article 10, Section 1 makes it very clear that the members are the council's making a very broad grant of authority. And it needs to be a broad grant of authority.
If it's as broad as you say, by using the word affairs in Article 10, Section 1, and then the D.C. provision about affairs, there really isn't. What's left that hasn't been delegated?
Everything that the council retains. So everything that the council...
Tell me what it is.
Everything that the council identifies in Article 5, Section 2, the authority over setting requirements, the authority over elections, the authority over setting the direction of the organization, and the authority over amending the Constitution.
Aren't those affairs of the corporation as defined in that D.C. provision? The boards of directors?
They potentially are, but because the Constitution indicates that the council has specifically retained those, then they're not delegated.
Doesn't say that. I don't see the language specifically retain. It just says it shall do these things. Just like in, Article 5, it says the decision on membership dues shall be a majority vote.
Well, I'm referring to the code section, DC code section, which, as I recall, states that this is what the affairs are, but the question is always going to be what's been retained. So it's a general grant of authority, and let me find that here. It's a general grant of authority but it's limited to the extent that the National Council has indicated that it's holding something back. It's really the question of whether you have to look through the Constitution to find the articulation of a grant, or whether you look through the Constitution to find if something's been held back. And from a practical standpoint, from a practical standpoint, it really needs to be that the grant is broad, and the only thing that's retained are those things that are enumerated in order for an organization to operate, in order for a board to be able to operate.
But I still don't see, given what you've described as what being the business affairs, the affairs of a nonprofit corporation under D.C. law, what conceivably has been retained in the Constitution for the council, and other than possibly conducting elections to the board?
So we relied upon DC code for identifying what those affairs are, the general powers, and 29-403.02, which talks about general powers, says, unless its articles of incorporation provide otherwise, every nonprofit corporation shall have, I'm misreading it here. Well, I'm going to have to use my minute and a half to answer something other than that question. I mean, it's our position that
normally I wouldn't allow that, but okay.
It's our position that it has whatever powers have not been specifically withheld, and we acknowledge that some powers have been specifically withheld. But going back to your question, I think the other point about which there's really disagreement is what is a requirement, and on that point, because Farthest North in their briefing, in their final brief, denigrated the significance or importance of the Blue Book. I want to spend just a minute on that because I think it's very important. If you work through the governance documents here, you start with the Congressional Charter. The Congressional Charter says that the corporation may adopt and amend a constitution, bylaws, and regulations. So part of what the corporation can do includes bylaws and regulations. You go to the Constitution. The Constitution talks about how the National Council or the National Board of Directors shall have the power to adopt bylaws. So again, authorizing bylaws here. And then you go to the bylaws, and the bylaws talk about a Blue Book of Basic Documents. This is Excerpt 102, Article 8, 102, shall be distributed and shall contain requirements for credentials as established by the National Council. And then you go to the Blue Book of Basic Documents, and there is in the Blue Book of Basic Documents a section entitled Credentials. See Constitution Article 8, which refers right back to the article that we've been talking about. That's at Excerpt 107. And then if you look at that, it identifies what the requirements are. And on this point, it's a requirement to pay dues. It's not a requirement to pay dues of a certain amount, because that's something that's been a shared power that both the council and the board have to respond to day-to-day circumstances. I think I'm in the red. Okay. Thank you.
Please add a minute onto the rebuttal.
Thank you very much, Chief Justice. Just a few of the points that were just raised. Council is confusing this requirements concept. He's referring to Article 9, and Article 9 is a constitutional mandate. It says all members must pay a fee. The members of the delegates of the council will never change that at a council meeting. That's a mandate. It's in the Constitution. The only way that can be changed is through a constitutional amendment. What the delegates do at the National Council is set the requirement of, well, how much do you pay for that fee that you are required under the Constitution to pay? That's the requirement. And those requirements, the ones that are voted upon by the delegates at the National Council sessions, those are the requirements that the board is authorized to issue standards upon that are not inconsistent with those Article 8, Section 1 requirements. Council is trying to argue that when they established fees of $15 and $25, it wasn't inconsistent with Article 9, which said you must pay a fee. No one ever said it was, but it's irrelevant to the discussion here. The question is, when they established 15 and 25, is it inconsistent with the requirements established by the council at its session in 2009, where they affirmatively voted for a $12 annual dues? So he's really kind of mixing apples and oranges there. I think it's, for discussion purposes, it's better to just refer to Article 9 as a constitutional mandate, and then what comes out of the council sessions are the requirements. And if the $12 wasn't a requirement, well, what was it? I mean, some wishful thinking that we hope you all follow? I mean, it was a requirement. The National Council stated what the rule was going to be. Another problem, a major problem with Council's and GSUSA's interpretation of Article 10, Section 1, and you are absolutely right, Your Honor, that empowerment section of the D.C. Code says all powers. And so if, in fact, the National Board has the power to assess dues, it also would have all of the other enumerated powers, which would include the power to elect, the power to appoint officers, the power to set policy, the power to amend the bylaws and Constitution. It would be all those things, but we know they don't possess that through Article 1 or Article 10, Section 1, because Council concedes it doesn't. So it doesn't mean what they want it to mean. And I lost my train of thought, but I'm also out of time, so thank you very much, Your Honor.
Thank you, Counsel, and thank you to both parties for your excellent briefing and your excellent argument here today. We'll take this matter under advisement, and we'll be in adjournment for today.
Thank you.